Hello and welcome to this Western Governors Association webinar addressing the importance of state authority under Clean Water Act Section 401. We are excited that so many folks could join us today for what I'm sure will be an informative discussion. My name is Ward Scott. I'm a policy advisor with WGA and will be moderating this webinar. We have a diverse audience today with varying levels of experience and familiarity with Section 401 and the issues surrounding the program. This webinar will serve as a general overview of the legal and administrative framework of the Section 401 program, and we hope that this discussion will lead to future webinars in which we may discuss more nuanced aspects of Section 401 and its implementation around the country. We are joined today by Jeanne Christie with the Association of State Wetland Managers and by Darrell Early with the Idaho Attorney General's Office. I will provide more formal introductions for each panelist before their respective presentations, but at this time I would like to hand over the mic to Kevin Moss with WGA for some logistical information regarding the webinar.
Hi everyone, this is Kevin Moss with WGA. We're going to have opening presentations from Darrell and Jeanne, and we're also going to have opening remarks from Jim Ogsbury. After that, we'll engage in a moderated discussion, and as part of that, all of you, we'd like you to send in questions for a Q&A process. And so to do that, if you hover over the bottom part of the central part of your screen, there will be a cloud button that you can click on, and if you click on that, that'll enable the chat box, and then you can direct your questions that you'd like Ward to ask the panelists directly to me, Kevin Moss. So you can do that through the chat box, then you can select my name directly and send me any questions, and I'll pass them on to Ward. Thank you.
Thanks, Kevin. Now I'd like to introduce Jim Ogsbury, Executive Director of the Western Governors Association, to provide some opening remarks.
Good day and greetings from the mile-high city of Denver, Colorado. I'm pleased to welcome you all to this very important discussion about the importance of state authority under the Clean Water Act, Section 401. The Western Governors Association represents the governors of 19 western states and 3 Pacific territories, and we serve as an instrument of the governors for bipartisan policy development, information sharing, and collective action on issues of critical importance to the western United States. And the elected and appointed officials of those western states have a long history of working together and responsibly managing land and resources in their jurisdiction. Western governors recognize the importance of a close and productive working relationship between states and the federal government, and understand that more effective cooperation depends on the treatment of states as full and equal partners in the development and implementation of federal policy affecting state equities. Accordingly, WGA is committed to building a stronger state-federal relationship. Federal decisions and actions that are informed by state input and consultation produce more effective, informed, and durable policy and regulations. I commend your attention to WGA Policy Resolution 2017-01, Building a Stronger State-Federal Relationship, which highlights contexts in which the state-federal relationship plays out and identifies ways in which that relationship can be improved through better consultation and coordination. Nowhere are effective partnerships between state and federal agencies more important than in the context of water resources. States possess primary authority for managing, allocating, administering, protecting, and developing their water resources, and are primarily responsible for water supply planning within their boundaries. State water laws in the West have developed over the course of decades to reflect local customs and necessities. In enacting the Clean Water Act, Congress deliberately established a system of cooperative federalism whereby states, in partnership with federal agencies, are granted meaningful authority in the implementation and enforcement of the Act's various programs. The Federal Clean Water Act is largely administered by states, incorporating state expertise and decision-making. Under the Act, states have the authority to establish water quality standards under Section 303 and to assume primary permitting authority under Sections 402 and 404. Perhaps the most significant of the authorities granted to states under the CWA is the Section 401 State Water Quality Certification Program, which requires state review and certification of all federal licenses or permits for activities which may result in a discharge into waters of the United States. Western governors have been concerned about various calls to alter the Section 401 certification process by curtailing states' authority under the Clean Water Act. These calls have been based on limited instances of denials or delays in the certification process, which do not merit sweeping statutory or regulatory changes to a program that has resulted in the efficient, effective, and equitable review and certification of thousands of projects since the enactment of the Clean Water Act in 1972. On August 9th, WGA, joined by a coalition of 10 associations of state officials, sent a letter to congressional leadership expressing the importance of state authority under Section 401 and urging Congress to, quote, reject any legislative or administrative effort that would diminish, impair, or subordinate states' ability to manage or protect water within their boundaries, unquote. In addition to WGA, the coalition letter was signed by the Association of State Wetland Managers, Conference of Western Attorneys General, Association of Clean Water Administrators, Association of Fish and Wildlife Agencies, Council of State Governments, CSG West, the Western Interstate Region of the National Association of Counties, the Western Interstate Energy Board, and the Western States Water Council. The Western governors strongly support the efficient development and streamlined permitting of infrastructure projects. Nevertheless, process reform must not come at the expense of state authority. States have responsibly exercised their authority under the Clean Water Act to protect their water resources and their citizens. There are many other aspects of the permitting process that do bear analysis and improvement. I want to thank Jeanne and Darrell for joining us in this important discussion, and I look forward to hearing their remarks and their viewpoints. Now I'd like to yield to Ward, who will introduce our panelists.
Great, thanks, Jim. Now I am pleased to introduce our first panelist, Darrell Early. Darrell is the Division Chief of the Natural Resources Division of the Idaho Attorney General's Office. He supervises deputies and staff representing the state of Idaho and its natural resource and environmental agencies, including the State Land Board, Department of Lands, Department of Fish and Game, Department of Parks and Recreation, Department of Agriculture, Department of Water Resources, and Department of Environmental Quality. Prior to taking this position in 2017, Darrell was a Deputy Attorney General representing the Idaho Department of Environmental Quality, where his practice included hazardous and radioactive waste regulation and site remediation, federal facility compliance, complex mine site cleanup, and natural resource damage recovery. Ladies and gentlemen, I present to you Darrell Early.
Good afternoon, everybody. Thank you for that very nice introduction, Ward, and thank you for inviting me to present on this very important topic. I'm sort of waiting for my slides to come up on the screen, but I wanted to sort of...
I passed them to you. You can advance them yourself.
Oh, there we go. There we go. All right. So just as an introduction, this is the first time I've ever presented by webinar, and so I'm probably going to be a little awkward at this juncture. And secondly, this is the largest group I think I've ever presented to. I'm counting about 350 folks on board right now. This presentation was originally developed for CWAG and a group of about 20 lawyers. And of those 20 lawyers, almost none of them had any level of familiarity with the Section 401 requirements. And so the goal of the presentation then and now was to provide a sort of introductory familiarization to Section 401, the legal requirements associated with it, and how it is applied, so that as the issue of changes to 401 certification authority were presented, people could understand what those changes might mean as it relates to how the Act has been applied in the past. And that's really the way I'm going to proceed with the presentation today. Let's see if I can advance. I have to, as always, provide the usual disclaimer that anything I say is my opinion and not those of the Attorney General himself, which is pretty standard. The presentation outline will pretty much follow the framework up on your screen. I'll discuss basically the statutory and regulatory authority and the two seminal cases that have discussed the implementation of 401 from the U.S. Supreme Court. There are a host of circuit court and district court opinions out there because this is a matter that is often litigated in the courts. But the two seminal cases really provide the backbone of how this works. I'll then move on and talk a little bit about how these things are applied. And finally, using a current certification process that I'm involved in, I'm going to talk about some of the complexities that are associated with 401 certifications and why sometimes 401 certifications take longer than people might otherwise expect. I am prepared to discuss, if anybody is interested or wants to ask questions, Senate Bill 3303 and how it may change the law as it relates to this, and obviously any questions that I can answer towards the end of the panel, I'll be more than happy to do so. So to begin with, we'll talk a little bit about the statutory framework associated with 401. Section 401 is found in 33 U.S.C. 1341, and it provides that any applicant for a federal license or permit to conduct any activity which may result in a discharge into navigable waters must obtain from the state a certification that the discharge will comply with the applicable provisions of the Clean Water Act, in particular sections 301, 302, 303, and the toxics rules in 307 and also 306. That seems pretty straightforward. The thing that's important to recognize is that it's not just the discharge itself. It is the certification applies to the activity that is in play and not just to the discharge per se. The statute requires that it must comply with the requirements of that. But oftentimes when you're looking at a project prospectively, it's very difficult to determine whether something will or will not comply with the Clean Water Act standards. And so in the regulations interpreting this, the EPA has come up with the idea that what is really required is a statement that there is a reasonable assurance that the activity will be conducted in a manner which will not violate the applicable water quality standards. And that's found at 40 CFR section 121.2. That reasonable assurance language is very important because that allows the states to certify projects even when there is some degree of uncertainty about exactly how the project will be implemented and constructed and whether or not it will specifically meet or not meet water quality standards. And so what the states ultimately do is provide this statement of reasonable assurance that water quality standards will be met. Another important aspect of the authority here is the sweeping scope that it gives to the states, because in section 401, it provides that if the state does not certify the activity and denies the certification, no license or permit may be granted to the federal agency or to the applicant to the federal agency. And what this essentially does is it gives the states a final veto over a federally licensed project. And the courts have interpreted that very broadly to say that, you know, this gives the state a veto power based upon environmental concerns that the states may have. The other thing that is important in this regards is that the authority under 401 allows both the certification to contain effluent limits and other limitations and monitoring requirements necessary to assure that the applicant will comply with the applicable standards. And it also goes on to say, and this becomes very important because it, when read in this same context, it goes on to say, any other appropriate requirement of state law set forth in the certification shall become a condition of the federal license and permit. So this authority in 401 gives the states not just the power to grant or deny the certification, but also to impose conditions upon the license or the permit necessary to comply with the standards. And it also goes beyond just the standards to apply to any other appropriate requirement. And once those are in the 401 certification, the federal government must include the standards or those conditions in the permit as a part of that. 401 applies and is exercised by the state in which the activity will occur, and that can become important because oftentimes you have water bodies that are in more than one state, but it also has provision that allows for downstream states to participate in the process as well. If a downstream state believes that an activity occurring in an upstream state will have impacts on their water quality, they have the authority under Section 401 to also participate in this process, to request a hearing and to submit their comments and their recommendations to the administrator of EPA for the purpose of conditioning a license. And again, once a downstream state asks for those conditions, it is part of and can become part of the license in order to meet downstream state requirements. And on another jurisdictional note, a very important aspect of this is that tribes, Native American tribes, have authority under the Clean Water Act to receive treatment as a state under Section 33 U.S.C. 1377. Once they are granted treatment as a state status, then they have the full authority of Section 401 as well. When you're in Indian country, typically the EPA has the MPDS authority, and other federal agencies have to exercise their authorities inside Indian country in conformity with their trust obligations. But this Section 401 authority really can give the tribes a great deal of veto power similar to that exercised by the state. And even when the tribe does not have TAS status, they are very oftentimes treated as a downstream state for purposes of the preceding section that we just discussed. And so regardless of whether they have treatment as a state status, tribal governments are oftentimes involved in the 401 certification process via the downstream state treatment. And that can become particularly true in large hydroelectric projects that are going to affect quite a bit of river miles on large rivers. There are two primary cases out of the U.S. Supreme Court addressing the scope of Section 401. The first one up on your screen is a case called PUD No. 1 of Jefferson County versus Washington Department of Ecology. It's typically just referred to as the PUD No. 1 case. This case involved a hydroelectric project, and the state had imposed a minimum stream flow requirement on the project to protect designated uses for fisheries. The PUD protested that, and it ultimately ended up in front of the U.S. Supreme Court, and the primary argument was that the minimum stream flow requirements were not the type of numeric water quality standards or effluent requirements that were traditionally viewed as part of the 401 certification process. The court basically looked at that and said that the language of 401 is broader than just the effluent requirements, and it points specifically to the other appropriate requirements of state law language at several places in the decision to find that minimum stream flows can be part of a state's water quality standards. And what's really important is they did not really go on to define what is and is not within the scope of Section 401. In fact, as noted in the highlighted text on the slide, they basically said we're not going to speculate about what may be incorporated by the language, but at a minimum, the state water quality standards, which in this case included these minimum stream flow type requirements, as part of the designated uses were, excuse me, were within the scope of 401. The second case out of the U.S. Supreme Court to address 401 is a case called the S.D. Warren versus Maine Board of Environmental Protection case. This case involved a situation where it was another hydroelectric project. There was a dam on the river, and then the water was diverted out of the river and run through a power canal and then discharged back into the river. And Maine, again, wanted to impose a minimum stream flow below the primary dam that was blocking the river prior to the power canal. And the argument that was raised by the power company was that there was no discharge of a pollutant in this case. All that was happening was the water was being diverted out of the river, turned into this power canal, run down the power canal, and then turned back into the river without the addition of any kind of pollution to the river itself. And they said that did not constitute a discharge as should have been interpreted under the Clean Water Act. The court looked at that analysis and basically parsed the words and said that discharge as used in Section 401 is not the same as discharge of a pollutant as is used in Section 402 with respect to MPDS permitting. It specifically looked at the definition of discharge of a pollutant and discharge and basically said, well, in this context, any kind of discharge would qualify, and it looked at the dictionary definition of what a discharge is and said, well, that's just anytime you're letting something go into that, and it cited two examples of language like the Hudson discharges into the Hudson Bay, and basically it said, so even though there's no addition of a pollutant here, Section 401 applies to these kinds of activities, and that again really broadens the scope of what Section 401 can do, because it doesn't require that there actually be a discharge of a new pollutant. You can simply have a project that's discharging water, but because it's a discharge of water, you can reach to some and impose conditions on the project necessary to address water pollution. And in the example I'll talk about at the end of this with the relicensing of the Hell's Canyon project, that's actually a pertinent consideration. The primary one of the primary pollutants that we're trying to address in that case is a thermal discharge, and the reservoir system itself contributes very, very little thermal pollution to the system. It's mostly occurring as a result of other activities, not the operation of the reservoir system itself. And yet, because the reservoir system is the point of discharge, that thermal discharge can be addressed in the 401 certification for the relicensing. A couple of other important things to know about Section 401. Appeals concerning 401 certifications are a matter of state law, meaning that typically you have to challenge the 401 certification, except in very rare circumstances, through state courts. And ultimately, if you want to get it to the Supreme Court, you have to get it up through on cert from a state court decision. And in both the PUD case and I believe the S.D. Warren case, those were the provisions that were invoked. These are not appeals included in 33 U.S.C. 1369. And as I mentioned, they are only appealable via state law with one, to my knowledge, one exception, and that is natural gas pipeline cases. There was an amendment to the Natural Gas Pipeline Act a number of years ago, which does provide that review of 401 certifications can be held in the Federal Circuit Court where the project is located. And if there's a challenge to the timeliness of the certification request, that challenge is heard in the D.C. Circuit Court of Appeals. That issue came up in the Constitution Pipeline case in 2017, and the court there declined jurisdiction over the timeliness challenge The case was brought in the Federal Circuit where the project was located, the Second Circuit, but the Second Circuit declined to rule on the timeliness issue, saying it did not have jurisdiction. And then it went on to affirm the state certification in the review of the actual merits of the petition. The other issue is a question about whether or not 401 certification terms are enforceable as a matter of citizen suit provisions. And it's always been understood that you could sue over the failure to certify under the citizen suit provision, but there was some question not whether or not a citizen suit is actually available to enforce a 401 certification. So in a circumstance where an activity has been permitted and there is a 401 certification that imposes conditions upon the project, can a citizen suit be brought for violation of the provisions of the 401 certification? And just recently in a 2018 case out of the District Court of Oregon, the Federal District Court in Oregon, that's noted up on your screen, the Chutes River Alliance versus Portland General Electric, the District Court ruled that under 33 U.S.C. 1365 F5, 401 certifications are an effluent standard that are subject to enforcement by a citizen suit in the in federal district court, and allowed that suit to proceed in the face of a jurisdictional challenge on that regard. Ultimately, in that case, and I encourage anybody that's involved in this to read that decision, the court ultimately ruled that there was no violation of the 401 certification. And the reason that's important is that it's a good illustration of how 401 certifications can be used in a flexible way for adaptive management of projects. And the case is a good illustration of that. And it showed that the deference that the courts are going to exercise to the state regulatory authorities over how 401 certifications are applied and whether or not they are in fact being violated versus not violated. And so in one sense, this case stands for a proposition that you can bring a citizen suit, but it also stands for the proposition that states are granted a great deal of deference in that regard. So just to recap and talk a little bit about the application, again, these 401 certifications can apply to any activity. They're not just limited to construction, and they're not preempted by the Federal Power Act. It involves any project that may discharge, so it doesn't have to be an actual discharge, it's just a potential for discharge, and it does not require that it be a discharge of a pollutant, and it's not limited to point sources. There's been large articles written about whether or not you could use 401 certification for example, approval of grazing leases on federal lands. You can also condition the certification on laws reasonably related to water quality, and downstream states can be considered. And let's see, make sure I get through this. The agencies are required to include the conditions imposed by the state, and the agency may not grant the permit if certification has been denied. The final thing to point out, and I guess I missed this and I was going through my slides earlier, is that 401 certifications are required to be issued within 1 year of the date that the application is received. And if the state does not act within that 1 year period, the certification requirement is deemed waived. And that sort of brings us to the first of the significant complexities involved in 401 certification, and that is the issue of timing. There are any number of reasons why 401 certifications don't always come in within the time period of 1 year. Oftentimes, as is illustrated, for example, by the Constitution pipeline case, it has to do with the completeness of the application and whether or not the state believes it has sufficient information upon which to make its certification decision. The other issue that really comes into play, especially in large projects like hydroelectric relicensing, is simply the complexity of water quality. As I mentioned in the slide, water quality ain't easy. And the effect of that is that sometimes the issues that are raised are so scientifically complex, it takes a lot of work and a lot of discussion to get there. The other problem you have is that there are so many agencies involved. Oftentimes you can have border waters like we have with the Snake River here in Idaho. So you have 2 state agencies issuing the certification. You can have downstream states and tribes involved, and you can have multiple federal agencies also involved, including National Marine Fisheries Service, Fish and Wildlife Service, FERC, Bureau of Reclamation, Army Corps of Engineers, et cetera. You can oftentimes have conflicting standards between the 2 states, which I can illustrate a little bit with our Hells Canyon project. And you also have to determine whether or not these conditions are related to water quality versus other things. And finally, and probably just as significantly, is that oftentimes there are a lot of political considerations that go into these certifications as the various proponents of the project and the opponents of the project use the certification process to work through that. So I just wanted to use as an example, the Hells Canyon complex relicensing process. This process has been going on since, officially since 2003, so about 15 years now. And that's when, in 2003, Idaho Power Company submitted its first request for certification. Every year after that, it has withdrawn its request for certification and simultaneously resubmitted the request for certification in order to continue the conversation with the regulatory agencies and receive a certification approval. If it didn't do that, the result would likely be a denial, at which point the relicensing proceeding would not be allowed to proceed forward. There are any number of issues in this that deal with this. One of the most contentious has to do with whether or not there should be fish passage on the Hells Canyon complex, and we have essentially conflicting requirements under state laws. In Oregon, there's fish passage required on all projects like this, and in Idaho, we have a similar requirement, except that it does not apply to the Hells Canyon hydroelectric project. So in Idaho, we don't require fish passage on Hells Canyon. Oregon also has a provision that they refer to as part of their water quality standards, which is the biocriteria standard, and it basically requires that in this context that there be passage in order for there to be marine-derived nutrients in waters that traditionally had them, and what that basically means is dead salmon. So Oregon's water quality standards point in the direction of reintroducing or bringing salmon above the Hells Canyon complex. Traditionally, there were fish above the complex, and then after it was built, there were none. That issue has been very controversial, and as a result, this project has, as I said, been going on for about 15 years now as we work through this. There are other issues. The primary pollutant issue that is involved is a temperature issue. As I mentioned earlier, Hells Canyon is the point source for the discharge into the Hells Canyon reach where adult salmon spawn, and during a certain period of the year, the water gets too warm for salmon spawning, and that is a violation of both Oregon and Idaho water quality standards. The complexity of solving that is quite daunting, because most of the engineered solutions would lead to violations of other water quality standards, in particular mercury. So you have a scientifically complicated process, and the solution for it is very complicated, and that again has led to sort of the slow process of getting this relicensing through in the 401 certification. In addition to which, there have been any number of legal challenges, including a petition to FERC for declaratory ruling on the 401 certification, which both Idaho and Oregon opposed, and now a pending provision in the DC Circuit by Idaho Power related to that FERC petition. I guess I would like to conclude by just sort of pointing out or reminding from Jim's comments at the start, 401 as a legal matter is one of the state's primary authorities to control and maintain control over the development of water resources in the state because of that veto power and the ability to condition permits that is granted in Section 401. And for that reason, as Jim emphasized, changes to Section 401 should be very carefully evaluated, and hopefully the brief presentation I've provided today will give everybody the primer that will allow them to look at what is being proposed in S3303 and understand how it changes the playing field with respect to 401. And with that, I'll turn it back over to Kevin. Thank you.
Thanks, Darrell. Next, I'm pleased to introduce Jeanne Christie, Senior Policy Analyst and Executive Director Emeritus with the Association of State Wetland Managers. Jeanne was the Associate Director of the Association from the spring of 1999 to the end of 2000 and Executive Director from 2001 through August of 2018. She is committed to supporting the Association's primary mission, which is to support the incorporation of sound science into public policy and assist states in building state wetland program capacity. Jeanne has led projects to improve wetland restoration science, respond to proposed revisions to the Clean Water Act jurisdiction, improve wetlands mapping methodologies, and a host of other science and policy-related projects. Prior to joining the Association of State Wetland Managers, Jeanne worked as a resource conservationist with the USDA Natural Resources Conservation Service, Section Chief and Acting Branch Chief with the Wetlands Division of the EPA, and as an environmental planner with the Wisconsin Department of Natural Resources. I would like to introduce now Jeanne Christie with the Association of State Wetland Managers. Jeanne?
Great. Thank you very much. How was my audio?
It sounds great.
Okay, super. Well, thank you, everyone who took time out of what I am sure is an already busy day to participate and listen to this webinar today. From the standpoint of the Association of State Wetland Managers, and obviously many others, this is a very important topic. I just want to reiterate that cooperative federalism is extremely important to the states. And it's also, that importance is, as folks have said previously, is encapsulated in the Clean Water Act. And I think a lot of us agree that the Clean Water Act essentially defers to the states, particularly with respect to water quality resources. And I think that 401 certification is, in some respects, sort of the perfect example of how cooperative federalism can work. Water quality standards are administered by the states as well as the tribes that have received designation as treatment as a state. And I think we have some folks from the tribes on today as well, since this is a very important topic for them also. Because it's in the Clean Water Act, it's a section that states can readily take advantage of. It's available for everybody. It's highly flexible. The Association of State Wetland Managers, about a half dozen years ago, interviewed 10 different states around the country to find out how they were running their 401 program, and we sort of came up with a low, middle, and high level of sort of incorporation of 401 certification into how the state protected its water quality in the state. So it's how states use it, what they use it for, et cetera, is tailored to the specific needs of the state. It also avoids duplication by avoiding the need for the state to develop a separate permitting process if its water quality standards concerns can be addressed through a federal license or permit. And states have, in many cases, chosen to do that. And also because it has the ability for the federal permit and the state certification of that permit or license to occur concurrently, there's the opportunity for there to be good synergy around the work of federal and state staff in reviewing some of these projects. And then from our standpoint, as I'll point out, it's most often used with the Section 404 wetland dredge and fill and stream dredge and fill permitting. It provides kind of a baseline that states can use if their next step is to develop a permitting process, a state permitting process. So it has the potential for growth both in terms of the administration and resources that the state puts into 401, as well as the potential to provide a starting point for developing an independent state regulatory program. So what the states usually use Section 401 for. Here's a list. When we've talked to states over the years, this is what we have heard. It's used most often for Section 404 Clean Water Act, and with a subset of those actions under 404, there would also be a Section 10 Rivers and Harbors Act. And in many cases, states don't have their own state dredge and fill permitting program, and in fact, they will then use the 401 certification program to condition. And tens of thousands of 401 certifications are carried out every year through the 404 program. Many of these are through the nationwide permits that the state gets a chance every 5 years when they're reissued to condition, deny, or just certify without condition. The 402 program, there's a couple states that have not taken over the NPDES, National Pollution Discharge Elimination System program, and they would issue 402, 401 certification when EPA is issuing the permit, and then also ballast water off the coastlines, 401 certifications used to condition and make sure water quality standards are met for states with respect to the use and discharge of ballast water. Darrell already, I think, spoke extensively about some good examples with FERC hydropower licenses, and then also in the cases more recently that have received a lot of attention, the FERC energy pipeline licenses. The Department of Energy, when it's an interstate pipeline, there's a federal permit. And then these are the ones that don't happen very often, the Coast Guard permits for bridges, and then other nuclear power plant could have, if there are a new one being built, a thermal discharge. So there's some others in there that don't happen very often. They're very rare, but they are used if there's a concern around water quality as an opportunity for the state to certify. So to try to sort of get a sense, I told you previously that 404 is the primary permit that is conditioned under using 401 certification. And so what I'm going to do in this slide and the next one is give you a sense of the level of staffing around the country and the variability with respect to 401. And to understand that, I need to demonstrate here with this particular slide that when you're looking at that, the blue states and to some degree the purple states would issue, the blue states would issue 401 and their own state dredge and fill permitting pretty much simultaneously. So their staffing is commingled, and it's, when we're talking to states, it was really impossible for them to say how many staff they had for state dredge and fill permitting versus 401, because that's where most of the staffing is for 401 certification. And the purple states here are ones that have coastal programs that protect some of the wetlands in the state. So look at this one, and you'll see there's a lot of these light blue states. Many of these are going to be states that use 401 certification solely for their permitting the state or 404 dredge and fill programs. And so when we ask states with respect to wetlands and stream dredge and fill permitting how many staff they had, you'll see the red states had less than one person or less. The orange states had 1 to 4. The 5 to 9 for the yellow, 10 to 19 for the green, 20 plus for the blue. And then some states just had a really hard time figuring it out and dividing it up. I'm just going to go back and say, so look at the red and orange states, the ones that don't have a lot of staffing. And if we look up here with the light blue states, there's a fairly high amount of correlations. Also the drier part of the country for the most part, which is where there would be few activities to permit with respect to water quality, fewer flowing waters. And the wetter parts of the state, of the country, have in many cases elected to develop their own independent state dredge and fill permitting programs for a variety of reasons, and many of these are very carefully coordinated with 404. A number of years ago, Minnesota, which has its own state dredge and fill permitting program, decided they weren't going to do 401 any longer, and we, in discussions with them, pointed out that that would have an impact on these licenses that have nothing to do with wetlands and stream dredge and fill permitting. And a few years later, they restaffed that position, because even though what this program is primarily used for is dredge and fill permitting, these other complex large projects that happen with respect to pipelines and hydropower and other sort of issues are extremely important to the states and the state's responsibilities for maintaining water quality standards. So given that we have highly different levels of staffing around the country, I want to make one more point here before we go on. One point here. When I mentioned earlier that when we talked to 10 states a few years ago about what they use 401 certification for, none of these states listed pipelines as something they used it for. And I think that speaks to, the change and the fact that there is kind of a new activity on the landscape, which are these extensive pipelines going across the country to transport natural gas. And for a state, in talking to the states, a pipeline is a pipeline is a pipeline, and they permit pipelines for natural gas, they permit them for wastewater, they permit them for drinking water, and conveyance of various things. So when the state is looking at 401 certification for a particular activity, it's the activity, it's not what's being conveyed, only insofar as that affects, how to make sure that water quality standards are being met. So that the state is viewing the pipelines as conveyances and how to make sure that they do that safely. What being conveyed is not the issue. So in addition to the different levels of staffing and activity with respect to the different kinds of permitting, states are variable in their interpretation of Section 401. So exactly what action triggers receipt of a request for certification is different. And as an example, in one state for the Section 404 program, the core district will say, all right, here's a public notice with no information, and that starts your review request. And in another state, the district will provide a complete application before saying the receipt of request for certification is triggered. So the federal agency has a role in this. They also have a role in the length of time to carry out the review. I know that earlier it was said that there's a year, and at the same time, for example, with respect to 404 permits, that time's 60 or 90 days or shorter periods of time than that. How and what conditions are adopted, even though I think Darrell has made a good synopsis of what the Supreme Court has said with respect to this issue. It's anecdotally we've heard over the years that some federal agencies are variable, and even from one part of the country are variable in terms of whether they adopt all or part of the conditions. And they also are variable in whether or not they provide information to the state automatically or upon request of the adoption of conditions. And then there's also variability with respect to enforcement of those conditions. So it's impossible to generalize across the country how Section 401 is working and being applied. It's going to change from one part of the country to the other in terms of staffing resources, in terms of what kind of permit it is that or license it's being applied for. And Darrell's pointed out that complexity is a big issue. A lot of these nationwide permits under 404 are very simple actions that, you know, putting in a dock or putting filling a very small amount of a wetland to build a house, a bunch of, you know, putting in culverts. Some of these are very simple as long as the footprint is very small and they get issued easily. It's the larger, more complicated ones. And with all of these, there are differences from federal agency to federal agency and at least to some degree to one part of the country to another. So I think it's like 3 or 4 years ago, the Association of State Wetland Managers was putting on our annual meeting, and we'd heard something about FERC relicensing a pipeline, so we put a presentation on it from FERC, and I can only say that the room became instantly electrified. We had no idea this was a topic of enormous concern to many of the states until we did a presentation on it. And I think at that point in time, we could have stopped our annual meeting and focused only on some of these pipeline project issues. There was so much interest in the topic. So over the next year, we put together a proposal that has been funded by the U.S. Environmental Protection Agency that we've been working on for almost 2 years. This project wraps up in November. And here's a list of the different products that we have been developing, the goal of which is to improve the effectiveness, the efficiency, the transparency, and the predictability. These large projects, when the permit shows up on someone's desk, can be over 1,000 pages in length. And the parts that the state might be interested for water quality certification purposes are admittedly not 1,000 pages. They may only be 20 or 30 or 40, but people in the state need to be trained and conversant in, you know, how to handle these, because they may, as I pointed out earlier, be something that they've not dealt with previously. So we're doing a bunch of work on identifying a guide for best management practices, building on a lot of wonderful work that others have done. We have a new cumulative adverse effects tool that and white paper that is currently under review and will be available for folks to adapt as they see fit. Understanding the process that is undertaken to receive 401 certification is complicated, and these processing maps we're working on, the examples, and we'll have a tool that states can use to develop their own is another piece. Trying to put access to a lot of good information in one place is something we're doing. And we've learned that it's complicated in language and everything else, working back and forth between consultants and companies and states and federal agencies. So we put together some information to help with that. And we are doing 4 webinars. We've completed 2 and have 2 more to go that are recorded enough on our website. So we think we have a fair amount of information from the states and a team of 33 experts around the country that have helped us put this together, and we're very excited to be able to share this with everybody going forward. Not surprisingly, as a result of doing this project, we have some ideas about what would address some of these issues that we think that well, we know the states are concerned about, we know applicants are concerned about in terms of receiving permits and certification. And here is a list here. It's our strong belief, at least on behalf of the Association of State Wetland Managers, that these are the things that, the kinds of activities that would be important to address in order to provide greater certainty and clarity and efficiency in the permitting process. We're very concerned that changing the law is going to sort of have the opposite effect. It's going to make everything unclear. And so essentially what we're saying is one problem right now is that you heard me say earlier that sort of when the timeline starts for 401 is not entirely known. It's variable from project to project, and in many cases it's too late. These big complicated projects may require an environmental impact statement. FERC in licensing has sort of pre-application pre-meetings and processes. And the states, if they are involved in those early discussions and not, folks don't wait until, you know, the permit trigger is pulled and they receive an application to look at, then the state can raise its concerns. It can ask for the information it needs concurrent with the federal agency's request for information, so the applicant doesn't, you know, get these additional requests for information much later in the process because the state hasn't been part of it earlier. And we believe this would expedite and make it a lot easier to get the permits and the 401 certification sort of carried out. There are opportunities, you can see with a lot of products that I listed previously, to increase clarity about, you know, sort of what everybody needs to do who's, you know, on first base, second base, third base. And then there needs to be adequate staffing and training for folks that are going to be handling these, particularly these complicated projects. And so by providing, I mean, I know it's not very exciting to say, well, we need training and we need folks engaged early in the process, but this is what we believe will really work. And we hope folks will consider these recommendations carefully, and we look forward to talking to states and the other state organizations in more detail about some ideas about how to move ahead with this. I just want to say that, you know, some of these recommendations, you know, we've been talking to the states over the years, and there are a lot of training needs. And you can see over here on the right side with the amount of turnover right now we're having with staff around the country as people retire that have been in their projects for many years. It's just like, you know, how to review a permit application, what's your criteria for denying it, you know, how do you integrate requirements into permits or 401 certification. I think there'd be enormous synergy around trying to share how different states do it and finding some common sort of ways to be consistent. I think that'll help applicants and states and ultimately better protect the water quality resources of the state, which is our ultimate goal. And those are my remarks, and I'm turning it back over to Kevin or Ward and hope we have some questions.
Thank you very much, Jeanne. Now I'd like to open up the discussion to questions from our attendees watching the webcast. Please type your questions into the box on the WebEx screen. We've already received several and want to begin there. To both Darrell and Jeanne, what are your positions? You had both mentioned, and I'm sorry, I've received several questions on this. I'm trying to condense them into one. You had mentioned the waiver of state authority for failure to act within 1 year of receipt of a request for certification. What are your positions on this state waiver? And is it true that the federal agencies are the ones that are allowed to prescribe rules for that timeline and the commencement of it? And are there states that have established their own rules? For example, what would constitute a complete application?
Darrell, do you want to go first? Should I go first?
It can't be heard, apparently. Hello?
Yes, we've got you, Darrell.
You got me online now?
Yes, sir.
Okay, sorry about that. I will take a stab at that. Thank you for the question. I can tell you as a matter of the way Idaho at least practices, my understanding, hopefully if there's anybody from Idaho on the line that would contradict me, don't please. But my understanding is that we basically run the clock from the day we receive the application, and we work to obtain the information required within to issue the certification with that clock running from the date of the application. With respect to whether or not FERC or the other federal agencies sort of can unilaterally make that determination, I think the better view is ultimately that's a matter for the states. The Section 401 allows for the states to, provide for public notice in the case of requests for certification, public hearings, et cetera, and I think the states could set, as a matter of state rule, if they so choose, the requirements for when they will consider an application complete and thus start that running. Now, to the extent that a state has not done that, I think that sort of leaves a void where the federal government can, in its way, go forward in that regard. But I think if a state sets up its own legal conditions for when the applications are deemed complete and therefore starts that clock, that would be an appropriate mechanism for the state.
This is Jeanne, and Darrell, that's excellent. I would say with respect to the waiver of state authority and the ability of the federal agencies to potentially do that at the end of 1 year, if the state is actively, sometimes the state itself elects to waive on a particular permit for a variety of reasons, but the state is actively trying to issue a certification. I think the waiver is a bad idea because there's no guarantee that water quality standards within the state, that are going to be met. And if there's a violation, it means at least that whoever received the permit could be subject to enforcement action by the state for failure to meet water quality standards. So there's the issue of, will there be a future enforcement action? And that's not an easy decision for a state to make, but it's possible that it could occur. With respect to the timelines, Darrell covered that. I would just say that states are trying to figure out how to make this work. I mean, sometimes it's tough. Some kinds of information that a state may want can only be collected because of the seasonality of it at certain times a year, and so that can lead to delays. Another big problem that shows up is that states for pipelines and other linear projects want to know where how many streams are going to be crossed, how many wetlands are going to be crossed, where are they, what are they? And so a pipeline or a road or anything else could have, and does have, hundreds of crossings even within a single state. So what I think Pennsylvania does is, but the problem is that the folks trying to put the pipeline in can't get on the private property unless they have kind of a license from FERC to do so, and so they can't give the states accurate information about how many streams and wetlands, et cetera, are going to be affected. And so the state will issue a conditional 401 certification, which makes it possible for everything to proceed, and then allows for them to do a final certification at the end of the project when they have all that, or at the end of the process where they have all the information if there's any changes they want to make to it. In our experience, states do not like to deny a permit. It rarely happens. They know if they do it, it's probably going right to the governor's office. I'm sure the governor's offices know as well. So those decisions are not made lightly at all. So thanks.
Yeah, and this is Darrell again. I would just add that one other aspect of this is that the applicants have a tremendous incentive to work with the states, and to the extent that there's an information problem that's out there, or the science is uncertain, there's a great deal of incentive to work collaboratively to help that, because the last thing they want is for the state to say, we don't have enough information to certify this and therefore we're denying it. And we can't provide reasonable assurance that it will meet water quality standards. And so and that's the reason why in these very complicated projects you oftentimes see the submittal, resubmittal, submittal, resubmittal dance that goes on, so that they continue to provide that time to the state to work through the science and work through the information issues and get to the right answer. Because if the state has its back against the wall, on that 1 year time frame, they may be in a position where they have no choice but to deny that, at which point the federal license cannot be issued. And so there's that hammer, it provides for a great deal of collaboration.
Great, thank you. Next question is, could you talk a little more about developing a definition for cumulative adverse impacts? Who would be developing that, and how could that be utilized?
So this is Jeanne, and if it's referring to the product that we're working on, it's a tool. It's not a definition. It's a tool to help states sort of and others think through what the potential cumulative adverse impacts might be, and to be able to reach some conclusions about the things that need to be addressed because they might lead to cumulative adverse impacts during the application process. It's not the same thing as a definition. This is something to support and provide for a sort of consistent method of doing that analysis. And it's we did do a webinar on it, and it's going through final review, and it'll be out as a product here in the next couple months.
Great. Darrell, do you have anything to add to that?
I think that one's probably not so much a legal issue for me, so I'll defer.
Okay. With differing adjacent downstream state tribal standards and 401 certification requirements, which takes precedent, or how are they reconciled? What, if any, role is there for the EPA?
I'll take a stab at that one. As I understand it, and primarily based upon what the statute already provides, is that the EPA administrator acts as sort of the conduit for downstream state comments, and going back into the, I believe that's in subsection 2A2 of the Act, Section 401, there's a discussion about whenever the discharge will affect the state, the administrator, which is the administrator of EPA, will notify the downstream state, and then the downstream state asks for a request via the administrator for a hearing, and at that hearing, the downstream state presents its evidence about its impacts and what its conditions would be, and then the administrator, based upon those recommendations, imposes the conditions then that are requested by the downstream state. So that's, as I understand the way the process works. In our Hells Canyon proceeding, the downstream states have been participating. We have 2 states that are actually issuing the certification because it's a border water, and so each state has its own water quality standards. But then the Snake River ultimately passes into the state of Washington and is adjacent to and nearby waters of the Nez Perce tribe. And so you end up with those downstream states, and they will probably start to weigh in. They've been involved and they've been informed and have provided some comment to date, but this formal process will probably kick in here as the state 401 certification is finalized. And once it's finalized, then they'll have that second opportunity to sort of make sure that their standards are being complied with as well. Because until they see what the final license looks like as a result of our 401 certifications, it's harder for them to evaluate what impacts there will be that aren't addressed by the 401 certification.
Excellent, thank you. And Darrell, while I have you on the spot, you had mentioned that the Supreme Court declined to rule on what may be incorporated by the language of 401 in terms of the scope of state review. Have lower courts spoken on this issue? Specifically, have federal courts overturned a state decision because it addressed matters not related to water quality and therefore beyond their authority? And if so, what were the conditions or matters that were not related to water quality?
That is a a very difficult question for me to answer. I believe there have been some decisions like that, but there are, I can't even begin to count the number of cases, both at the state level and in the federal system that that involve, mostly in the state system, as I mentioned, that involve challenges to 401 certifications. And most of these, as again I mentioned, they'll be in state court, and to sit down and try and research and review all those is something I've not done. Like I said, I would suspect and am pretty sure there are cases out there where they've said, no, this is not reasonably related to water quality. This is something completely unrelated, and therefore we're going to deny it. But the Supreme Court has not yet really weighed in on that. The best that they've come up with is, they know them when they see them kind of analysis. These are, in the case of the PUD case, they said they're clearly water quality related. One of the issues that comes up in our Hell's Canyon is the issue of the fish passage and whether or not fish passage is a water quality standard. And Oregon has one statute that's based outside of its water quality standards that says, you're supposed to have fish passage on it. And Idaho has a standard that says, no, you don't have to have fish passage on Hell's Canyon. And there's an argument out there to say that neither of those fish passage requirements, which are actually found in our Fish and Wildlife Code provisions, neither of those are water quality related. Oregon, however, has what they refer to as their biocriteria rules, which are part of their water quality standards, and which do require, or could be interpreted to require, some form of fish passage in order to allow for those marine-derived nutrients to be present in the water. And so that could be argued that is a water quality. The net effect is the same, fish passage. And so it can be very complicated, and states can, through their the way they craft their water quality standards, can get to a lot of issues that some people might say are unrelated to water quality. And others would say, no, they're directly related to water quality.
And this is Jeanne, and I would, the reason, maybe some folks don't know, that the reason that having dead fish is important is that's the food for the fry. And the little salmon don't, they starve to death if they don't have it. Is that correct?
There's that. There's also other species of fish that evolved to depend on that. Bull trout, for example, as I understand it, there's science to support that bull trout sort of evolved in streams, or at least certain subspecies of them have evolved in streams to depend upon essentially the decaying salmon flesh and the amount. And there's also other macroinvertebrates and other types of things you don't even think about in terms of oftentimes we think of fish when it comes to water quality, but bugs and other things like that are just as much a part of water quality and indicators of quality of water. So marine-derived nutrients under the Oregon rule is something that they've taken very seriously. That's not a standard that's found in Idaho's water quality standards, but it is part of the Oregon water quality standards.
And I'll just add that in our discussions with the states with respect to whether they are adding, sort of conditions that are outside of water quality standards, their answer is no, they are not. That just as Darrell has explained, because this has been an area of settled law, because the courts have consistently ruled that the states can use other parts of their state authorities to provide conditions that will help to support water quality standards, may be critical to doing so, they've done it that way. And so, when we talk to them, they say, no, all of these things have to do with aquatic life standards. They have to do with, ensuring recreational uses, other designated uses. And so Darrell pointed out that folks can, have different interpretations of what's appropriate, but the states we've talked to and conferred with are very clear that their conditions with respect to water quality standards are focused on achievement of water quality standards.
And these are issues that are being litigated right now, and that's another reason why I'm a little hesitant. I know that there's in the Millennium Bulk Terminal case in Washington, there's allegations that essentially the decisions there were driven by non-water quality related matters, but those are obviously still in litigation, and there will be further proceedings in that regard. So we'll kind of leave it at that.
Well, thank you very, very much, both of you. While we're talking about ecology and the interplay between species and 401 certification, are state agencies conducting 401 cert reviews required to consult formally or informally with the federal agencies, particularly the Fish and Wildlife Service and the National Marine Fisheries Service, during the review to determine whether there will be impacts on the listed species under the ESA?
Jeanne, you want me to handle that?
Yeah, you go ahead with that one.
Okay. Technically, the states are not required in the 401 certification process to engage in consultation, as that term is understood. Consultation is a formal process that applies to the federal agencies that are associated with the issuance of the federal licenses. That's not to say that there is not discussion with the services in particular during the 401 process, but the actual formal consultation occurs after the 401 process has been completed usually. And there again, it's kind of a, because the ultimate permit has to contain the conditions in the 401 certification, the actual permit that will be the subject of the consultation isn't done until the 401 process is complete. And so it's, in order to keep the cart and the horse in the same alignment before going into consultation, you got to get through 401 so the services can then formally evaluate the impact to the listed species or the threatened species. And it's for that reason that doesn't happen. But like I said, in a lot of the meetings that we go to on some of these projects with respect to 401, as we're working through these very complicated conditions, the services will be there and they will be providing input and their thoughts on the conditions as it goes along. And so it can be a collaborative process in that regard.
Great, thank you. A couple more questions. How might the Commerce Clause under the U.S. Constitution affect the legality of states' decisions under Section 401 in cases of interstate or even international utility projects where water quality certification conditions might differ from state to state? I'm sorry, water quality standards might differ from state to state. This participant is aware of an instance where a state was recently threatened to be sued under the Commerce Clause by an international energy company. Could you please speak to that?
I'll take a stab at that one. It's complicated. And in fact, this issue is at play in the Millennium Bulk Terminal case. There are allegations that the states are preempted. There is authority out there that holds that when a state is acting pursuant to federal law, then there is no Commerce Clause violation because the federal government has essentially empowered the states as a matter of federal law under Section 401 to impose conditions on these projects. The argument is out there, and there's case law to support, as I recall. I can't remember the citation off the top of my head, that when you're acting in that capacity, that you're not violating the Commerce Clause. The arguments that are being advanced in the Millennium Bulk Terminal case are tied in some respects to discrimination against interstate commerce, in particular the allegations that Washington is using its veto power over the terminal to basically block the international trade in coal to China by preventing it from being offloaded and onto ships at this terminal. Again, it's a matter in litigation. I know that a number of states have weighed in on this on both sides. I know that there have been amicus briefs filed by some of the coal-producing states in support of the Lighthouse resources, there have been a number of states that have filed amicus briefs in support of the state of Washington's position on that there is no preemption or Commerce Clause issues. The case is proceeding in court, and I suspect will ultimately get some scrutiny on those issues.
Great, thank you. And Jeanne, we're going to send the last question to you, which is, and Darrell, you're certainly free to weigh in as well, but how do you effectively increase inclusion of states into the pre-application process in Section 401 reviews?
By inviting them to the table at the beginning. So, I mean, there are, and we can provide this. It's been done. This is not something that's unheard of. There have been cases where the states have been invited during the NEPA process, the pre-certification process, where the states have become, you know, in some cases they become savvy enough about it, knowledgeable enough about the process to know that they can ask to be involved. As I said previously, for many states, they, 10 years ago, they never saw a pipeline project, and now those same states may see lots of them. We're working with one of the tribes on this project, the Fond du Lac tribe up in northern Minnesota. Their reservation is not very large, but they've got 17 pipelines going across it. So there is the opportunity to voluntarily bring them to the table right now, and you can address it that way. So I think it's more, if the states want to reach out and start talking to folks, there's also, I guess, there's this new federal one-stop NEPA process that's being pursued by the administration at this point in time to make the EIS and EA review go more smoothly, and obviously one thing to do would be to include the states as one of the sort of required partners in that, because I think it would save a lot of time. So states can become more conversant on the process. They can ask to be at the table. It can be recommended. I believe there's some rulemakings and stuff, a new policy review that's going ahead. And we certainly, when we've had the opportunity to have recommended this step, be explicitly recognized in going forward.
I'll add.
Oh, sorry, Darrell, go ahead.
Yeah, I was just going to add, I think Jeanne's comments are exactly appropriate. The states have the opportunity to participate in the NEPA process at a very early stage. They can be a support agency to the federal agency. Part of the problem is just setting up the networking and the infrastructure to facilitate that participation, and then also getting the resources to the state agencies that it requires to participate in these processes. And so, for example, on mine permitting projects in Idaho, we have an MOA that we've set up with or an MOU, I can't remember which it is, but it's set up with the Bureau of Land Management so that they involve us in their permitting activities with respect to large mines on federal lands early in the NEPA process, so that things like water quality standards and groundwater quality standards can be addressed in the NEPA process early on. And then when it comes time to whether it's the issuance of a state permit or some other state activity like a 401 certification for an NPDES permit or the mine permit, we've already sort of been there at the table and talking to them all along. And I think that's a very healthy thing.
Great, thank you both. I have one quick question, and for all of you watching the webinar that have submitted questions, I just want to thank you very much, and I'm sorry that we haven't been able to get to all of them. I wanted to put one more out there that was just a quick one, and the question is, for pipelines that require both 404 core permitting as well as FERC permitting under CPCN, is a 401 water quality certification required for each federal action, or is it one certification for all federal licenses?
It's my understanding that there's one required every time there is a permit or license issued. That said, if it's also important for the 404 folks to be at the table when the FERC licensing is going on. It's just as much a problem or has been historically a problem that the FERC pre-application and licensing process goes on, and then the Corps and the states don't get pulled in to address many times very similar issues between the two until late in the process. So if there are going to be 2 licenses or permits required, it would be good to coordinate those licenses and permits as well as the 401 certification. If one is being issued for one, I would assume they would use similar conditions provided that the same things were being licensed. And so 404 permits dredge and fill permitting, and there may be additional issues under the FERC license. So I don't think it's the same thing. They're 2 separate actions.
Yeah, and I'll just weigh in. I think it really depends on how the state wants to proceed, but certainly there is legal authority to say that they have authority to condition each of the permits separately, and that can come into play very interestingly. I'm aware of a situation, for example, where there is a nationwide 404 permit available that has been already certified by the state. So if a person comes in and elects to submit a notice of intent under the nationwide permit, and the permitting agency says, yes, we're going to rely on the nationwide permit, the state has already issued its 404 permit for that. It's already said under 401 that the nationwide permit will meet those standards. But there may be another opportunity for the state to otherwise step in and condition, because there may be another federal permit at issue. For example, there may be a need for a permit from the Coast Guard for a bridge. It involves a 404 dredge and fill activity, but it also requires a permit from the Coast Guard for the bridge. So even if the permit has already been certified under a nationwide, you might have a second bite at the apple. But again, it's up to the state on how they want to and how they want to go about doing that.
That's a great point, because yeah, that does, with respect to stream and river and wetland crossings, that does get complicated around the country.
Right.
Great. Well, thank you both for your excellent answers to these questions, and we want to thank Jeanne and Darrell for your time and expertise on this webinar overall, and really appreciate having you here. We also want to thank all of our participants in this webinar, all of our registrants, for your interest in this important topic. We hope that this will be the beginning of an ongoing dialogue and hopefully a series of webinars to address the various issues surrounding state authority under Clean Water Act Section 401. I want to let you know that this webinar has been recorded and will be posted to the WGA website as well as onto YouTube. Please feel free to share it with your colleagues or anyone that's interested. And for more information regarding Section 401 and other issues on which WGA is working, please visit our website at www.westgov.org. Thank you all again for your time today. We hope that this has been informational for you, and we hope to continue the conversation soon.
Thank you very much.